Good afternoon. My name is Robert Eckert. I am a board certified business litigation attorney licensed in Florida, Texas, and Washington, D.C. I've been litigating for over 20 years, and I'm going to speak to you today about covenants, representations, and warranties in this Drafting Dangerous Provisions NBI seminar. Now, while every word in a contract is important, there are some provisions that must be drafted with extreme precision because they play a central role in what we'd like to decide of the economic risk allocation. And those provisions we'll be discussing today. Now, regardless of the area of practice, all attorneys should have a nuanced understanding of the concepts of covenants, representations, and warranties. So what's the difference and why should we care? The basic definitions of a covenant is defined by Black's Law Dictionary as an agreement or promise between two or more parties, evidenced by a deed or writing, typically signed, delivered by the parties to each other, where each party may pledge or does pledge to himself and to the other something that's either done or will be done, or stipulates to the truth of certain facts. Now, it's important because a covenant is typically viewed as something of a promise of a future act or a future conduct. Now, when we move on to the definition of a representation, that would be contrasted with a covenant. A representation is defined by a representation or a promise of a present act or fact, typically to induce somebody into a contract or a material portion of the agreement that the parties will rely upon that representation. So a representation is an affirmance of a current fact. And again, contrasting representation with a covenant being a promise for a future act, a representation being essentially a promise of a current fact that's typically one that is material and induces the other party to enter into that contract. Now, when we look at misrepresentations are a false statement regarding a present material fact. And typically in the world of litigation, it's something that the defendant, if sued based upon a breach of a contract or breach of representation, that the defendant knew or should have known that the representation was false. And in many jurisdictions, they have negligent misrepresentation, fraudulent misrepresentation, and the only difference typically in those causes of action deal with the level of evidence or the scienter, if you will, the mental state needed to be proven, the burden of proof for those causes of action. Now, moving on to warranties. A warranty, defined by Black's Law Dictionary, in the context, for instance, in the sale of personal property, is a statement or representation made by the seller of goods contemporaneously with and part of the contract for sale. Now, this is important because the party selling the good or the party providing the warranty undertakes this promise, this guarantee, if you will, that certain facts are or shall be as claimed. It also is an engagement by a seller of goods to to assure the buyer that the existence of some of those facts affecting the transaction, whether past, present, or future. And that's something that parties often require to be part of the contract, that there be a warranty of the typical underlying contract, whether it be for goods or services. Now, warranties can be created outside of a contract. They can be created by statute, be it state statutes. Some state statutes, most follow the Uniform Commercial Code, or the state typically adopts the provisions of the Uniform Commercial Code, or if you're dealing with the international sale of goods, the Convention on the International Sale of Goods and Warranties. So the warranties that can be created by statute could be in the implied warranty of merchantability, warranty for fitness for a particular use. In Florida, we have a statute here, Chapter 672.607, that allows for a breach of warranty in the event the warranty proves not to be valid, or the seller did not provide the buyer with the product that it was intended for, or it failed to provide the buyer with what the buyer expected under that warranty provided. Now, there are certain defenses, and I know there will be speakers later in the program that will discuss things that will potentially give the breaching party, if you will, some way out of the agreement or based upon a breach of warranty. But in many instances, a warranty or a claim for a breach of the warranty could be a waiver of the warranty, could be a statute of limitations of the warranty. There could be case law or in the statute that the warranty there must be privity between the seller of the product or service and the buyer of the product or services. And the last research I did, state and federal courts throughout the United States are somewhat divided on the issue of privity. So you really have to pay particular attention to your jurisdiction. Also, it's been my experience in terms of litigating breach of warranty provisions that in some instances, so long as the seller provides for, or the provider of services provides for in the contract, a conspicuous disclaimer of warranties, that would be legally sufficient to preclude liability. Now, the plaintiff's failure to reject non-conforming goods, for instance, may also act to bar a claim for breach of warranty. So those are the essential terms and definitions for covenants, representations, and warranties. Moving on, literature on the distinction between representations and warranties is somewhat limited or sparse. As we discuss, representations are statements typically of a past or existing fact, and warranties and covenants are promises of future acts or the future truthfulness of the representation. And we can see these definitions played out in case law throughout the United States and in model agreements such as the Model Stock Purchase Agreement by the ABA or Model Asset Purchase Agreements. So, why is it important to understand these differences? It's because depending upon whether you are alleging a breach or drafting an agreement to protect your client for the specific essence of the agreement, is not to go too far outside the actual scope of what your client is intending to covenant, represent, or warrant. Is to avoid, as we said before, these agreements are intended to limit economic risk and exposure and non-economic risk and exposure, such as potential injunctive relief that could be available for an aggrieved party. So the different remedies that are provided based upon the different alleged breach or covenant, and I use that covenant in a general term, the general provision of the agreement. So depending upon the provision in an agreement, whether it's a covenant, representation, or warranty, will matter, because each one of those, and depending upon one of those or all three, may provide for different remedies available to the aggrieved party and potentially different defenses to the party that is claimed to have breached that particular provision of the contract. There may be statutes on point in reference to those, such as the Uniform Commercial Code, deceptive trade practice statutes, certain regulations, maybe under the Food and Drug Administration, when certain cosmetic goods or other materials that have to comply with federal regulation are regulated by regulation. So really, you really need to understand the purpose of what the portion of the agreement that you're going to be seeking relief in or drafting the provision specifically intended to protect your client, so that you could potentially limit the remedies available if in fact there is a claim to breach. And on the converse, if you are a plaintiff looking to recover damages or equitable relief under a specific provision of an agreement, then you want to know what provision will apply, whether it's a covenant, representation, or warranty, which may dictate what your claims are under that specific provision under statute, rule, or regulation. So drafting clear and concise representations and covenants. Some tips for representations to reduce the possibility of claims of misrepresentation. First, it's always important to potentially consider adding a knowledge qualifier. In other words, if the representation in the agreement contains a provision that says, to the best of my knowledge, or to my knowledge. Without one, it's assumed that things actually are or are not categorically the case. Now, when you have the benefit of drafting the agreement as compared to being provided an agreement, you may have the ability, if you are provided the agreement, to redline or revise the agreement to add qualifying language if you think it will protect your client. And when it comes to a day in court, and again, in my experience as a litigator, this qualifying language potentially could give the party that's being sued a way out, because now we have allowed for the trier of fact, if you will, to assess what the level of knowledge was of the party that has claimed to have breached this provision of the agreement, the representation, based upon the knowledge they had at the time that this agreement was entered into. So it essentially limits statements of facts to the things that the person knew or should have known at that time. There also can be an addition to include a reasonableness standard. An example of this would be a provision that says the company has complied with the law everywhere it was not reasonably likely to result in a fine. And in some instances, for instance, if there may be a merger acquisition agreement, there may be a sale and purchase agreement of a business. In some instances, there may be an asset purchase agreement or a stock purchase agreement. Whatever it might be, the selling company may want to include this reasonableness standard. And by doing so, the purchasing party, if you will have some further assurance that what is being represented, that the seller, whether again a stock purchase agreement, an asset purchase agreement, a product that's being sold, that the seller has represented that there are no, there's been a reasonable investigation, that there's been reasonably no levies of fines or liens against the property. And so again, that provides a little bit of a way out for a potential lawsuit in the event there is a claim breach of this provision. So it limits the application to actual events rather than the potential. Another example is that the company is licensed everywhere except where it would not negatively affect its business, or the company holds these certain licenses within this certain state so that the purchaser maybe of that business understands that this business cannot be operated outside those licensure requirements. There are also disclosing exceptions. And what is that? If the agreement specifically identifies that the seller or the buyer wants the seller to give a representation that the selling company or the seller of a product is not in violation of any laws, rules, or regulations. Sometimes this occurs in international contracts, the international sale of goods that I have been involved in. If a client of mine who's a manufacturer of medical devices is selling in the United Arab Emirates, and the potential purchaser of my client's business or the potential broker for this product that may be sold from the United States into the United Arab Emirates, the broker or the entity that may purchase my client's business, knowing he has these contracts, international contracts, the buyer will want to know, or the broker will want to know, that this company has no pending or is not aware of any violations of any laws. And certainly I have been in instances where these representations have been made and the selling entity or the seller of a product has a history of violations, be it with the Food and Drug Administration, be it with the International Commerce Division for international sale of goods. And so when these things happen, it's very serious and oftentimes like shooting fish in a barrel for purposes of litigation and summary judgment purposes in litigation. Another provision that can be modified, or at least a qualifier in these provisions, is adding a materiality requirement. And in terms of a materiality requirement, what the scope can be limited to is that the entity or the agreement that is being entered into requires that in order for there to be a breach or of a representation or a warranty or a covenant, that the representation is the performance for instance, of this agreement will not violate any material contract to which the company is a party. An example, again, using my client that sells medical devices. In certain instances, my client has an exclusivity agreement with an entity that purchases my client's medical devices. And in other instances, my client makes medical devices for multiple entities under different labels for that particular purchasing entity. So in certain times, in certain contexts, the purchasing entity will want an assurance that by my client selling these medical devices, they're not in material breach of any other contract in which they're a party. And unfortunately, in the world of litigation as we live, in the event this does become sometimes a problem where a purchasing entity or a purchaser of a product believes that this has been breached, then they could claim that there was some tortious interference besides a breach of contract. Now, materiality is something that has to be decided by a fact finder. And in the United States, where we have juries, materiality would be a jury question and not a legal question. So it certainly would get a party past summary judgment, which may be important from litigation standing, litigation strategic position. So materiality is often another qualifying term. And in terms of the agreements, this one word could allow for a way for your client to avoid future economic risk, and the party that potentially believes there's a breach may decide it's not worth fighting because of that litigated term, materiality. Now, realistically speaking, it's difficult. It is very difficult to account for everything that should be listed as a material expectation. But you can limit these provisions and the legal impact. Of course, while these statements are convenient, sometimes they can be drafted too broadly. So it certainly depends upon the parties and what the subject matter is of the agreement to consider whether the materiality or any provision, qualifying provision, should be a part of the the covenants, reps, and warranties of the agreement. Let me move on to covenants. Now, as we said, covenants are promises for future conduct. Some general tips for limiting the scope and effect of covenants. And in this instance, we have, and for purposes of the slide here today, we're using an example, employment agreements and covenants in restrictive covenants. But before we get into that, there are some general tips for limiting the scope of covenants. One, draft obligations narrowly. The narrower they are, the more protection that they typically would provide for the party providing for that covenant. Number two, provide for exclusions from broadly drafted covenants. So if you want to exclude something out, obviously it would not be included in the covenant. And I believe that the construction of contracts would say that if it's not specifically included, then it's been excluded. So if there's a covenant to do A and there's a claim that the covenant did not do B, I think that the fact finder or the court could determine as a matter of law that the obligation or the covenant claimed not to be provided was never something that was part of the bargain. And in this instance, the limiting effect of a narrowly drafted covenant will do that. The third thing is to add, as we discussed, materiality to the covenant portion. 4, convert absolute obligations into absolute obligations for the reasonable best efforts that will be done for purposes of covenants. 5, convert an unconditional covenant into a conditional covenant, which certainly limits the effectiveness of the covenant if it's conditioned upon a certain act or a certain behavior. In other words, the covenant that something will occur is conditioned upon the party that would ultimately potentially seek a remedy for breach of the covenant if they did not comply or do a condition precedent for the covenant to apply, whether it is for a non-compete agreement in the terms of an employment agreement, or the terms of the use of a product in a certain way, that maybe certain training must have occurred for the use of the seller's product in order for it to be used in its intended purpose and effectively. And if the party that is claiming breach didn't fulfill the training obligations in how to use that product correctly, then it would potentially bar recovery for a breach of covenant. Provide a grace period. Number 6, to cure nonconformance. So the party drafting the provision could include a provision in the agreement that allows for the party claiming to have been harmed to notify the represented party, or the party that has covenanted, made a promise to the seller or the receiver of services, that in the event the party that's claimed to have been harmed, or the non-breaching party, to provide notice to the other party to cure a claim for a breach of covenant. And 7, another way to limit the scope is to set a time period out within possibly outside of the issue of statute of limitations, but the party that is drafting the contract could put a provision in the agreement that limits the time in which the other party can bring a claim for a breach of covenant, and certainly limit the time more so than what the statute of limitations provides if there's going to be a claim for a breach of covenant. Now, as we said, getting onto covenants and discussing them in terms of employment agreements. A common form of covenant is a restrictive covenant in the employment context. It seeks to protect business interests of a company by limiting what an individual who left the company can do. And we see this in many jurisdictions, and certainly here in Florida, under Chapter 542.335, which governs covenants in restraint of trade, or as we like to call them, non-compete agreements. In their non-compete agreements in many jurisdictions that are created by the legislature are statutes that govern generally post-term employment activities. There are certain jurisdictions that, although they don't have specific statutory restrictions governing covenants in restraint of trade. Their law is codified with case law to essentially do the same thing. For instance, Delaware and the courts of chancery do not have a statute on non-compete agreements, but they have, by a creation of case law, essentially outlined for parties that enter into non-compete agreements the terms and the elements that would allow for a non-compete covenant to be effective or be enforceable, and how to have it construed. So if you're looking at a statute or simply case law, it's important to identify what these covenants are and what they regulate. And in purposes of covenants, Florida has, as I said, Chapter 542.335, and we also have covenants, or strike that. We have statutes that govern trade secret protection, and you might see covenants in an agreement dealing with trade secrets. In many instances, trade secrets are a valuable portion or a valuable asset, and maybe the biggest asset that a company is acquiring or a party is going to receive when it comes to work for a company. They may be given exposure to trade secrets. Trade secrets are defined, whether it's under the Florida or another state statutory provision, or it's defined by federal regulation. In the federal system, we have the Defend Trade Secrets Act. And in Florida, we have Chapter 688, which governs trade secrets. And trade secrets, which is beyond the scope of this presentation, but those covenants in terms of protecting them is important, either for a business that is hiring an employee that doesn't want the employee to learn a trade secret and go out and use that trade secret because they've appropriated it and to compete with that their former employer, or the purchasing company is buying this company in part because of their trade secrets. So the covenants are important to identify and to understand how they work synonymously with the statutory provisions that govern these types of matters. Now, in Florida, when we talk about covenants under employment contracts, we focus on what is the legitimate business interest of the party that is trying to protect their business. And in Florida, these covenants, or otherwise known as restrictive covenants, are used to benefit an employer's legitimate business interest. And legitimate business interest, there's a non-exhaustive list in Florida that provides for things such as customer lists, trade secrets, confidential business information, goodwill of the employer, certain training that might occur. So these are things that are often protected in restrictive covenants. And restrictive covenants only means that these covenants that the employer is going to provide to, say, an employee, restricts the employee from taking certain conduct during or after the fact that could harm the employer's business. And they are only and can only be used if they're intended to protect a legitimate business interest. So it's important to keep in mind the covenants you're drafted, and if they can be reasonably proven to benefit the company. Unfortunately, in a lot of litigation, in terms of non-compete litigation, sometimes employers like to try to cover the universe of things that they believe are trade secrets or confidential, when in fact, in many instances, or I should say in some instances, the training or the confidential material claimed to be confidential or trade secret is simply industry know-how or things that could be learned on YouTube. So when drafting these agreements, it's very important for the drafter to identify to the best they can what that covenant is intended to protect. Again, moving to things to avoid in restrictive covenants in restraint of trade or employment agreements. These covenants are, from a policy provision standpoint, many states or some states fail to give enforcement to restrictive covenants. These right to work states, these states that believe that covenants are too restrictive on employees being able to go out and earn a living. So it's important that the covenants that are drafted are specifically identified for the industry in which the business is in and is intending to protect. So that, and also by a creation of statute, such as here in Florida, the covenant must have a reasonable time restriction post-employment. And that's governed by the statutory enumerated timeframes within the statute. So in other words, if it's simply an employee leaving the business that has a non-compete agreement in Florida, a restrictive covenant of not engaging in competition for 6 months or less is deemed to be reasonable. And that's just an employee. Now, if we're dealing with the sale of a business or the sale of trade secrets, that's another provision of the statute that allows for the time period to be extended, in some instances between 3 years and 7 years, that the seller of the business or the employee that worked within the business and sold the business to another business can't compete if it involved the sale of the business or trade secrets or even a franchise. So those are, look at your statutes in terms of what's enumerated and draft these agreements accordingly so that they are consistent with the statutory framework. And I'll say this about employment agreements. Even if you were to draft an employment agreement or a portion of a contract that was a restrictive covenants, contained restrictive covenants, if it was deemed to be an unreasonable restriction or an unreasonable time period in the covenant, some states like Florida are called blue pencil states. They will modify the covenant to make it enforceable if it is in fact on its face unenforceable because of the time or scope, the geographic scope of the restriction. That is another area that covenants come into play where they maybe an employer tries to limit how far outside their geographic zone the employee is restricted from competing. And if it's a nationwide business, maybe the covenant says nationwide. If it's not a nationwide business and the employer is only in Florida, the court could blue line that covenant to make it just include the state of Florida, and the time restriction could be narrowed to a reasonable time restriction. So avoid the lengthy time restrictions or geographic scope restrictions if in fact it's not going to be enforceable. And again, depending upon your jurisdiction, in Delaware, the courts have moved in the direction of throwing the baby out with the bathwater. They will find a restrictive covenant to be unenforceable, and instead of blue lining that or modifying the covenant to make it reasonable in either geographic scope or the time limitation, they simply throw the entire agreement out. And so that would be probably a very bad thing if you were the lawyer for the employer that drafted that agreement, and your client, the business, no longer has any protections because the Delaware Chancery Court has decided to toss the entire agreement. Now, Moving on to choice of law and form selection clauses. Now, these are both risky provisions, I guess, can be risky provisions due to how every jurisdiction, and again, in this instance, restrictive covenants, treats restrictive covenants. So you need to be sure when drafting these agreements that you pay attention to the choice of law and maybe the form selection provision to ensure that both the procedural law that would apply and the substantive law that would apply. So in the event there is a dispute, the court is not intended to rewrite contracts between the parties, but give force and effect to what the agreement contains, and it can be a covenant or a warranty or a representation that this law's jurisdiction will apply, and the certain venue within that jurisdiction will be the applicable provision. Moving to covenants in terms of loan agreements. These are things that in a loan agreement that the borrower promises to do and remain under those obligations until the credit that has been extended to the borrower has been repaid to the lender. It should not require the borrower to do anything it's not already doing. There are some common exceptions, but compliance, accounting records, litigation, change in management, these are all issues that need to be considered for purposes of affirmative covenants in loan documents. Let me touch upon the compliance. An affirmative covenant in a loan agreement may require, and it could say that the borrower shall, which is a mandatory language condition, instead of may. May is a non-obligatory provision, but it's at the discretion of the borrower. In this instance, a shall provision would seem to be the most beneficial for a lender, but the lender could require that the borrower shall preserve and maintain all licenses, permits, government approvals, rights, privileges, franchises necessary to conduct its business. The lender is relying upon the borrower to fulfill these and continue to fill these obligations that is inducing the lender to provide that loan to the borrower. Should the borrower not do these things, then the lender's risk is substantially increased. In fact, it could be certainly argued without much effort that if the borrower does not maintain these covenanted obligations, such as their records, their permits, their licenses, and things of that nature, that the borrower would be in default of the loan obligation. Now, these obligations or these covenants can also be imputed to not only the borrower, but to any guarantor of the borrower if the lender should so desire. And these covenants of compliance are important to reduce risk for lenders, whether they be private lenders or they be institutional lenders. But certainly they are covenants that are reasonably necessary to ensure that the borrower complies with the terms as mandated by the borrower. And I've also seen, since I do have a government investigations and criminal defense practice, where there have been indictments for borrowers of loans from institutions that receive federally insured funds when the funds are not used for the intended purpose. Not only is this a breach of a loan agreement, but could be the basis for a bank fraud indictment. So beware that these covenants that are drafted could ultimately wind up in front of a grand jury in the event that the borrower breaches in some capacity. One instance that comes to mind just recently, where a borrower went to a lending institution and borrowed $85,000 to claim he was purchasing or using it for his business, when in fact he went out and bought a $60,000 Pokemon card. Now, I'm not into Pokemon, but I don't think the lender would have agreed to bargain and lend on that Pokemon card. And nevertheless, not only is that borrower in breach of the loan agreement, but that borrower was also indicted. Affirmative covenants when it comes to accounting records. Borrowers and lenders want to make sure that in particular, lenders want to make sure that the loan, and it may be a loan that is a line of credit, so that or a staggered loan, so that not all of the money may be made available to the borrower all at once, but the borrower may be required to maintain its books and records in accordance with GAAP principles, which is known as generally accepted, accounting principles to be applied, or non-GAAP, and allow the lender and permit the lender reasonable inspection or audit to examine such books and records to make sure that the borrower's risk has been minimized, or it is not increased from where it was once the loan agreement was entered into. Moving on to affirmative covenants in litigation. Borrowers and lenders often have a provision in their loan agreements that the borrower is required to notify the lender in the event of litigation or even threatened litigation. This is so that the lender, who may have a security interest in a collateral lien against property that the loan proceeds that were provided to the borrower and property used to purchase for the borrower for his or her business, the lender will have a security agreement, a note, a UCC1 lien on that equipment pending repayment. And if there's threatened litigation that could impair that collateral, likely the borrower will have an affirmative duty to notify the lender of litigation or threatened litigation, so that the lender can take the appropriate risk mitigation steps necessary to protect its interest. And in many instances, even in simple insurance coverage and agreements for car insurance, there's an affirmative duty by the insured to notify the insurer of a potential risk of loss, an accident, or claim that may be asserted against that insured party. And so this affirmative duty is a condition precedent to triggering the coverage that the lender or the insurer may provide. And so that's very important to understand. Affirmative covenants in terms of change in management. And again, dealing with loan agreements for purposes of either an institution or private lender, the lender may decide that this party that is that is being lent the money, the borrower. In part, the material aspect of the loan is based upon the borrower's background, training, and representation, and their management team. And certainly, if that management team were to change in any way, whether it be through resignations or disability or retirement or even death, that the borrower notify the lender of this change in management. So when you're drafting agreements for borrowers, this provision certainly would be more protection for the lender so that they are aware of a potential significant material change in the management structure so that they could plan accordingly. Moving on to negative covenants. These are things that the borrower promises not to do and remain under those obligations until the loan is repaid. So these things are promises of things that the borrower will not do. And in certain instances, we've seen certain industries, and most recently the cannabis industry or the CBD oil industry, explode throughout different parts of the United States. It could be possible that the lender decides that in the event that this particular borrower decides to branch off into this new emerging industry, that this could be a breach of the loan agreement. And as anyone that has been in touch with that industry, the marijuana, cannabis, CBD oil industry, knows that although states have regulated and have begun to, many states have begun to allow for not only medicinal use, but of course recreational use, it still remains a violation of federal law as a controlled substance. So banks are hesitant not only to receive funds from businesses that earn proceeds from federal from industries where there's federal regulations that make it illegal. This could be a negative covenant that could be, in his example, that the borrower will not engage in these things. And it could be other things too, such as the borrower will not sell to certain countries. Maybe there are countries that are deemed to be threats to the United States, embargoed countries, or that they have to comply with certain regulations as outlined by their industry. So these are considered to be negative covenants. I'm going to move ahead to drafting clear and concise express warranties. Express warranties definition. And in terms of warranties, many times we look to the Uniform Commercial Code, and in particular, this example is under Article 2, dealing with the sale of goods. Any affirmation of fact or promise made by the seller to the buyer which relates to the goods and becomes part of the basis of the bargain, it creates an express warranty that the goods shall conform to the affirmation or promise. And that's in the Uniform Commercial Code, section 2.303. Now, let me say this also about warranties. I just, as an aside, I often find it interesting where a party may contract with a service provider for, could be anything, heating, air conditioning, ventilation, servicing. It could be servicing of a vehicle. It could be servicing of machinery. And the party providing the service will, many instances, and in their contract, give a warranty. It could be a lifetime warranty. It could be a 5-year warranty. So my question always becomes to that party giving the warranty, well, the warranty is great, but what happens if you, the party giving the warranty, goes out of business and is no longer in business? or has the ability to fix what was warranted and can no longer do it. So the warranty in those instances becomes what I like to call a nudum pactum, which is Latin for a naked promise, because it really doesn't mean much. So in terms of express warranties, if they're provided, there may be consideration given that a warranty that's being provided should be conditioned upon a third party providing the warranty, such as a warranty company or some type of third party providing indemnification in the breach of a warranty. So that's just an aside. The sane course is to discard the word warranty from one's thinking. This is a quote from Carl Llewellyn, chief architect of the Uniform Commercial Code. The meaning of the word warrant, as argued or as stated, is moot and often unnecessary. In fact, Mr. Llewellyn has said that simply get rid of it. But that is certainly his thinking. Not sure many jurisdictions would follow that if that was the case, but that is certainly a viewpoint that I just wanted to mention here today. His suggestion was to use the words representations as compared to warranties. Are we talking about 6 of one and half dozen of the other? Are we really talking about the same thing? Sometimes it is a matter of semantics, but case law that distinguishes between the two needs to be considered. And I do believe that it's probably, in my opinion, that the UCC uses the word warranty, and representations are non-codified. It could play a difference in the remedy available if it's under the UCC or under common law in terms of representations. And if it's a statutory provision such as the UCC, it may provide for the recovery of attorney's fees, which we all know we like to try to get our clients' money back in the recovery of attorney's fees. And if you can do so because there's a warranty breach versus a breach of a representation, it may be the difference between allowing or having a statutory basis for the recovery of attorney's fees as to the American rule where each side pays for itself. Let me move on to considerations when drafting express warranties. There's always the issue of, in this type of litigation, of whether in fact what was stated was simply puffery. General statements about quality or superiority usually are not usually legally binding. Puffery as an expression of opinion is not to be made part of the representation of fact, but is simply exaggerated boasting that a reasonable person would not rely upon. In some instances, though, it can be interpreted as a warranty. And depending upon the specificity of this statement, this alleged puffery or non-puffery, courts will sometimes say, well, if there's an alleged breach of this, but it looks like puffery, but it's not specifically identified, had the parties meant it to be a material part of their covenants, representations, or warranties, then they would have specifically stated such and identified it as such within the agreement. So that's another consideration. For instances, statements such as state of the art, best coffee in the universe, are usually interpreted to be just simply puffery and not creating a warranty. But yet, even if it can be reasonably assumed that a statement is puffery, there's an inherent risk that it's going to constitute an enforceable warranty. And again, looking at the transaction as a whole, the agreement as a whole, the specificity of what is claimed, those are all factors that have to be considered. It's probably best to avoid vague assertions of quality or superiority in the event there's potential risks. Moving on to conditions invalidating warranties, and I see that I'm running out of time here, but warranties contained in agreements that they may say may not apply to certain situations. It may say that the warranty is void if the intended use of the product is not used for its intended purpose or in its intended way, or if there's been a neglect in maintaining the property or failure to maintain it in accordance with the manufacturer's specifications or causes. Just recently, my daughter we bought her a Jeep, and she put these big tires on it. And we believe that there was a problem there because it could invalidate the manufacturer's warranty on the Jeep with these massive tires. So those are things that have to be considered if the warranty, the party drafting the language that wants the representation needs to be aware of, and the party assuming the risk can also avoid unnecessary risk with the warranty. There are multiple other issues that will be considered when dealing with remedies, such as the duration and method, and disclaiming warranties and tips when drafting warranty provisions under the UCC. These provisions will be contained and outlined both in the statute and in case law, and they are further outlined in my materials. But should you have any questions regarding this, since it looks like my time is almost over on this portion of the seminar, my email address is robert@roberteckerdlaw, that's RobertEckerdlaw.com, should you have any further questions. And it's there up on the screen. And should there be any further questions, I'd be happy to help. Good luck, stay safe, and avoid the courtroom if you can.